So it's 4:20, and it's not lost on any of us that you've chosen your hit of M&A over your hit of MMJ, but just delayed for a few more minutes. Give it 20 and you can go out there and enjoy yourself. I'm so happy to be here. I want to thank the Lanes for having me. We share an anniversary. It's Benzinga's 8th year, and it's also my 8th year in cannabis, and who can relate? It feels more like 80. So thank you for having me. Really appreciate this, and really excited to dive in. We've got only a short period of time to cover a lot of material. You know, you've heard the expression, if you want to know about the road ahead, talk to people coming back. And all day long, and including this panel, these panels have just been steeped with knowledge and experience, and this panel is one of those as well. You know, I don't do math. I didn't get into Michigan on my math scores, but I think we've got like decades and decades of applicable experience and firsthand experience here that's relevant. You know, and also throughout the day, what we've been hearing about a lot is, you know, deals and M&A and the environment and what can kill a deal, and most importantly, how do you prepare to get to a place where you have the opportunity to have a healthy exit. So that being said, as the setup, I'm Sherry Tarr. I am also AKA the Queen of Compliance. I'm a recovering attorney. I run a firm called 68 Partners, and I help operators and brands prepare to exit with best compliance practices, sound product and market expansion, and strategic partnerships. So it's a protect and grow approach. So that being said, enough about me. Let me allow the panelists to introduce themselves.
Should I go next? Okay.
You should, Charlie.
Okay, all right, thank you. Charlie Alovisetti, I'm a partner of Vicente, based out of DC, Bethesda. I'm a Scorpio, and let's see, I look forward to talking about M&A.
Hi, everybody. I'm Erica Rice. I'm one of the co-chairs of the Cannabis Practice Group at Foley Hoag in Boston, and I am really an M&A lawyer by training. I've been doing cannabis and M&A specifically for also about 8 years, and can talk cannabis M&A all day, so glad to be here.
Good afternoon. I'm Lou Magazoo, and I am an attorney with offices in New Jersey. I'm a former county commissioner, former municipal attorney. Done about $6 billion in transactional work, cut my teeth on cellular and cable, which are very reminiscent of what we're having here in cannabis. And I've done about 24 cannabis deals in New Jersey, and looking forward to the pitfalls and opportunities with respect to cannabis M&A.
Yeah, and isn't that the point, right? It's not just about the pitfalls. It's about being prepared to take advantage of the opportunities, to preparing your business in such a way that when the market shifts, or when you get to a place where you want to take advantage of an opportunity that you weren't expecting, but you're prepared to seize that opportunity. And Lou, over the years, Lou and I have talked about this, and we talked about this in our group prep, about the importance of how you establish your business and how you operate your business is outcome determinative. And I come from pharma. And then after working for pharma, I actually flipped the script and became attorney and spent my legal career going after pharma, mostly in products liability litigation. And I saw, what happens when you're not operating in a compliant manner. So Lou, talk about that. You have so much visibility into how outcome determinative it is to run your business.
Yeah, one of the things I say to my clients is gravity does apply to this industry. Perhaps not when you're using the plant, but in every other time, gravity matters. And the same things that you'll find in other non-cannabis businesses, the same rules apply in the cannabis business. And Sherry used an interesting word, which is determinative. A few times I'm going to use some perhaps language that we don't use in real life, but it may not be dispositive, meaning it may not absolutely result in the proper result if you set it up correctly. But if you don't set it up correctly, it absolutely will be determinative, because it very much is garbage in, garbage out. So one of the things that ironically, if you're going to have a successful M&A, you have to have your setup correct at the very beginning, which means you have to have the right team around you, particularly people who've done this before. You don't want somebody, frankly, and that's just kind of an unfair thing because we all started once, not ever having prior experience, but at this point in this industry, there's a lot of folks with the experience of success and failure, and frankly, you learn as much from those failures as successes. But it's important to have a team around you that knows how to set things up and can anticipate both the good and, frankly, the bad, the things that could happen from the time you set up until the time of your exit.
Absolutely. And let's talk about that a little bit in terms of having the right people with eyes on these deals, right? So many of you have heard my expression, don't hire a dentist to repair your ACL. Super important to have the right advisors, the right consultants, the right subject matter experts, because listen, the evaluation of these deals, the due diligence team, it's comprised of people with various and multiple different lenses on this from their respective subject matter expertise. And every single one of them is looking for a reason to devalue the deal, is looking for a reason for that deal not to happen. So, Erica, we talked about this in our prep, and this has been a common theme I'm hearing throughout the day, just how important it is to surround not only your business, but especially when you get to a place, if you're fortunate enough to get to a place where you're even entertaining an M&A, that you have the right professionals on both sides of these deals, and you lit up when I said that about don't hire a dentist to repair your ACL. Talk about that and how that actually manifests when you're actually doing these deals in your practice.
Sure, yeah. So it's there's different aspects to the deal. I think that having the industry knowledge is really important because it is an unusual industry in a lot of ways, and there are pitfalls that if you don't know to look out for them, it's easy to gloss over them or not pick up on it until much later in the deal. That's something else we talked about. But like Lou said, there's also commonalities in the deals we're doing with all other kinds of deals. And so you don't want to have somebody who doesn't know how to do a transaction doing that particular type of transaction. Even I am not going to be doing a debt deal. My debt partner's here, in fact, and I would send her to do that work because I know I don't know how to do those deals. I know how to do M&A, I know how to do some other types of corporate work. I don't do the regulatory work. I have colleagues that do that. We don't even do the regulatory work in every single state. We have local partners that we work with when we need to because it's so easy to miss something and then you get really far down the road. And we were talking about there are different types of risks and different types of problems that you can run into. Some of them are solvable, whether that's through some sort of risk allocation in the contract or some types of structuring. Some of them are deal breakers and not solvable. And if you don't know what those are up front, you're going to spend a lot of time, a lot of money, a lot of resources, and get to a point where you get stuck or you have to go all the way back to the beginning and rethink everything. So that's why it's really important to get the right people who have kind of both the industry expertise and the substantive legal expertise or accounting expertise, financial expertise, business expertise, whatever the case may be, to help you on both sides, like you said, to really spot those issues early on, determine if there's solvable issues, and come up with a plan to have a real viable transaction.
And one of those takeaways, right, is know before you go, right? So there are different state regulatory schemes. There are limitations and prohibitions in different states, what a single operator can do with equity and the limitations on licenses. And so when you're talking about these inter and intrastate transactions, you need to know what that regulatory landscape looks like, what the limitations might be. So Charles, in your practice, talk about, it's complicated enough that you've got different regulatory schemes in the states, but shouldn't the people that have been involved in getting the matter to your desk have done some regulatory recon. We talked about the activity that's going on in New York, right, and all this flipping. I'm getting calls from people saying, I want, $7 million, and they're not even operational. And by the way, you can't even flip your license. There's a new Trade Practices Bureau in New York. There's a set of regulations that prohibit certain types of quote-unquote transfers. So Charlie, we talked about this, and you've got a lot of visibility into these issues.
Yeah, okay, just to try and be specific, to give specific advice here. So, one thing I would say for an M&A transaction is don't believe everything a broker tells you. If you take anything, I was going to say, on M&A, I say don't believe everything a broker tells you. On debt, I say double check the term sheet to see what's non-refundable on a debt deal. If you remember two things from this panel, those two things will save you potentially tens of thousands of dollars, and you can send a check to me directly if you'd like. But, okay, so we'll talk about M&A broker, right? So, you see this all the time. I get these emails. You guys probably get these emails. It'll be a list of, we have these licenses for sale. This state's, doing gangbusters, buy this license, what have you. And I get it. I've been criticized, when people have seen the risk factors I put together for financings. They say, you're not much of a salesman, Charlie. So that's true. I'm not. I was going to say, salesmen don't get sued for malpractice, but I have to be careful. But you take a lot of complexity and you squish it into one or two lines, right? And so it's worthwhile before you spend any time on a transaction, just saying, just as a headline matter, can you even do this deal, right? Because there's often ways of getting deals done, even when you're not supposed to sell a license, that can work, but you just got to understand going in, how much hair is on this deal, what's the level of regulatory risk, am I comfortable with this regulatory risk, and does it work with the corporate side of things, right? So the big thing here is can you do an asset deal in certain states, or do you have to do an equity deal? And obviously, depending on the liabilities of the company, this can be really important from a corporate perspective. And you may think of this as, asset deal, equity deal, it's all the same thing, you're buying the company. But the regulators can often think of equity versus asset deals as two totally different things. Like I said, I guess my third takeaway is never underestimate a regulator's inability to understand, the real world and or business. So yeah, that's my big thing, is just spend a little time up front making sure you can do the deal. And if you can do the deal, what's the level of risk? There's a level of risk to pretty much any cannabis transaction, I think. If it's subject to regulatory approval, there's always the risk, it doesn't happen, or it takes longer than you think it takes to happen, so.
Sherry, if I could follow up on that, because I think that's really an excellent point. Don't fall in love with the deal. The only people that deserve love are your significant others, your spouses, your children. Deals don't deserve love. Don't fall so in love with the deal that you do not listen to your professionals. I've had clients that I have papered up the deal, telling them all the problems with the deal, but they continue to move forward, and God willing, there won't be negative repercussions. And the second point I would make, to Charlie's point, is that don't think regulators aren't going to figure out something that's wrong. Don't think you can outsmart them. And I guess there's a third point, which is it's a buyer's market, which goes to my first point. There are lots of deals. If you have capital, and if you have a track record and you know how to do this, there's lots of opportunities. And this is not the market that it was 10 years ago or even 5 or 6 years ago. So if something is either too good to be true or has so much, to use the word, hair on the deal, be prepared to walk away from it, because there will be another opportunity. The worst thing that you can do, in my view, is to hire professionals and then not listen to them. Don't even spend the money. Because if you're going to put your trust into professionals, and they do want to get you to yes, but they don't want to get you to a yes that has really a bad consequence, either anticipated or unanticipated, be prepared to walk away from the deal, because there's another one around the corner. And don't think you can paper something over or hide something from either local approval agencies or regulators, because they will figure it out. And that really becomes a problem.
Yeah, you talk about paper the deal. Well, in my experience in medicine and law, not documented, not done. And so what I'm seeing is, and it gets back to the original point about preparing to exit, and if you're running your business like a real business, and you're running your business compliantly, and you're running your business with all of the proper process, procedures, and people in place to help you to run like a real business, when these opportunities arise, you're not spending your weekend, by the way, you could never fill your data room over the weekend if you've not been, right? If you've not been keeping proper documentation of all of the aspects of your business. So Erica, we talked about this a bit, about things that delay the deal, things that can kill the deal, and there's only so much work that you can get done to get the seller, mostly the seller, obviously, in a place where, you know, they're not bionic, right? We have to be able to be realistic. It might not be able to be consummated because the deal is so, they're so ill prepared. So let's talk about that. When those kinds of situations walk into your office and you get under the hood and it was a glossy pitch and it looked like like the fundamentals were basically there. You lifted the hood and it's like, where's your data room? Your data room's empty. Oh, and you don't even have a data room.
Yeah, well, and I know the topic or the title is avoiding licensing pitfalls, but I think, there's a lot of, that's not the only pitfall, right? I mean, there's a lot of reasons why deals might not get done. And some of it, again, is solvable, and some of it isn't. So it's really a matter of identifying up front, and figuring out, my job is not to make decisions. My job is to advise the clients of the risk. And so there may be a company that a client's interested in buying that has no data room. And this has happened before. We're not going to do any diligence. Okay, that's fine. Here are the risks. Maybe we can structure it as an asset deal so you have less risk on the liabilities, but then you've got to know if that works with the regulatory side. You've got to make sure, especially in an asset deal, but in all deals, that the landlord is going to consent to the deal because you need to transfer the lease. And obviously, in this business, real estate's pretty important. You need to make sure that the sellers understand the tax consequences, which can be very different in an asset sale versus an equity sale. Certain types of transactions, you might need the consent of all of your members or stockholders, and you might have one that is not willing to play ball. And you need to know those things up front because, I once did a deal where we went from, I forget how it started. I think it started as an asset sale. No, it started as a stock sale, and then it moved to an asset sale, and then to a merger. Literally, we had a version of the purchase agreement, the transaction agreement, for every single possible structure. Because every time we asked more questions, we kept getting more information and different answers. And if we had just gotten it all up front, we could have just structured it right the first time, not spent all that money redrafting the documents. It's taken much longer, to get the deal done to the point where we could even submit to the regulators, because then you've got, depending on the state, this was Massachusetts, so 3 to 6 months to get regulatory approval. That clock doesn't even start ticking until you sign the document. So we could have saved everybody a lot of time and money if we had really just thought it fully through and gotten all the answers we needed up front. So really important, to be able to respond to diligence questions, have information to be able to evaluate these types of risks and make sure you're going in just eyes wide open on both sides.
Absolutely. And it speaks to the importance of not cutting that corner because that corner cut is going to cut the value. And in the aggregate, all of those corners that you cut, all of those SOPs that you had AI do that I can't call AI to the stand, right? So all of those things that you did because you were operating, you say you're operating super lean. No, corner cutting is different than operating lean, right? And these are the kinds of, this is why you need along the way the right professional support to get you prepared and ready to take advantage of the pivots and the shifts in the market and be prepared to seize, as Lou was talking about, the opportunities that may present. So, have you ever had this is to all of the panelists, a situation where it was just not salvageable, where you had to say, I've got news for you, prospective client?
I'll give an example. So, I was going to say, because I was trying to think about how to break this down, right? I mean, the first question you should ask in any cannabis M&A deal is the structure of the deal permissible under both the state and the local rules, right? So, example here is we were doing a deal, company was basically insolvent. They wanted to buy certain assets from it. A number of the leases were basically toxic because the prices were, the rent had escalated too high. But it was a Pennsylvania license, right? So in Pennsylvania statute, you can't transfer the license, right? So this is, you got to ask that question right off the bat because it killed the deal because they weren't willing to take on the lease. You can't do an asset transfer of the license under Pennsylvania statute. Then the only question is, well, do we think we could somehow get some sort of like exemption from the regulators? Are we comfortable running a bill? I mean, it's a big ask just for one deal. So yeah, that would be a good example of the structure blowing up a deal. And the second, I guess, can you do the deal? How long is it going to take to get the deal? Do you have to ask for pre-approval? Some states you can get approval basically after the fact. It's its own risk, right? If you get denied after the fact, what happens? Then there's the local question. And then I guess the fourth one I would say to ask right off the bat is, do the buyers own a license? Are they comfortable with a background check? Are you cool on that? Because that's another nasty one to discover, at the last minute, oh, by the way, I can't provide a list of my LPs to the regulator. Okay, that's great, but you're not going to get the deal approved. So, you got to come up with a game plan for that.
Lou.
I would just use the old Reagan quote of trust but verify. And I'm not even sure that I use the trust aspect. I'll give a brief war story that is illustrative of my point. Fortunately, I've done about 24 deals, and I am 21-4. I remember the 4 that I lost. One of them, the client came to me, and it was to a cultivation in agricultural residential zone, meaning there are homes there. And I said, I don't think this is going to work. And the client said, I was absolutely told by the zoning officer that this will be approved. And I said, my instincts of 43 years tell me it's a problem. We walked into the planning board hearing with 150 people, including a row full of nuns in the front because it was near a nunnery. So I had God against me. But the result was that the zoning officer who made these assurances, and by the way, we lost, was fired because she made the same assurances to a lot of people. And the client, and this is just another example, when I tried cases, I used to tell juries, don't leave your common sense at the door. Same thing about businesses, about this business. Don't leave your common sense at the door. And I'm going to speak kind of both sides of my mouth, because if you're here, you're by definition successful in probably some other business, which means that you're smart. So be prepared to engage with your professionals, not override your professionals, but to Erica's point, all we can do is advise you. So be prepared to have a fulsome discussion of the problems and liabilities. I would be very reluctant to do a deal and then go for approval after the fact. I think that's very, very dangerous. And I think you need to make sure that you have all of your approvals in place, because even if you have a conditional, it becomes very difficult to unwind. And frankly, you're going to spend a lot of money getting to the red zone and not go through all the way as my Eagles did last year. So, how to put the Eagles, but the opportunities, and I'm going to probably be my last thing to speak. I want to say this thing earlier. This is a buyer's market, and there's a tremendous opportunity if you get into it at the right price and with the right team, and frankly, the right in total portfolio of the project.
I set a personal goal for myself, which is really challenging. We've got a panel of 3 practicing lawyers and 1 recovering lawyer, so 4 lawyers, that we're going to finish on time. So we're going to beat the buzzer. We have 40 seconds left. We're going to do a quick, each person give us 1 takeaway for the audience, and I'll kick it off. Compliance is like Jell-O. There's always room for more. Do it early and often, like voting in Chicago. Charlie.
Regulators treat asset and equity deals differently in certain states, towns.
Get the right people on your team early and identify risks to see if they're solvable.
If it's too good to be true, it probably is, but there are not an absence of solutions, but an absence of creativity that will stop a deal from closing.
And we did it.